for the purpose, however, it's for the purpose to secure the repayment of a debt. So what security providers or lenders, what they do is that they want to secure that debt, and which means that they can then sell the property if you do not fulfill your obligations in paying back that debt. So a bond is something that attaches to either movable or immovable property to secure the repayment of a debt. Now, we get two different types of bonds in South Africa that we deal with on a regular basis. Most people don't know much about notarial bonds. You may have heard about it before, but we are all very familiar with mortgage bonds. Mortgage bonds are bonds that are registered over immovable property. So this is over land or your home, which is built on land. That's why we call it immovable. You can't just pick up that piece of property and move it somewhere else. And notarial bonds are registered over movable property. So this is an interesting a solution for when there's not an immovable property available. You can register a notarial bond over vehicles, equipment. There are people who register them over their Ferraris because there's actual value, real value in immovable property. In movable property as well. When it comes to notarial bonds, we have two specific types, which are general notarial bonds, and we have special notarial bonds. General notarial bonds means that if I were to register in favor of a bank, a general notarial bond, that bank is able to come and take my property generally. Any movable property that I have falls under that general notarial bond. Stefan is going to talk to us about how that's done in practice, but for the sake of simplicity, that it covers all my property generally. Again, movable. So they can take my chair, my furniture, my vehicle, if that falls under there. Special notarial bonds are registered especially over certain movable property. So like I mentioned before, Ferrari, valuable vehicles are often have notarial bonds registered. And then also in the sense of business, and this is where we more often see notarial bonds, it will be registered over machinery and equipment of big businesses. Sometimes, if we have to look at a company that is manufacturing goods, they might be renting their warehouse space. They don't have anything of value other than their equipment. And in this event, the lenders will require a notarial bond to be registered over that equipment. All right. I'm going to be talking about bonds in the greater scheme of things, but focusing more on mortgage bonds. But I will tell you the distinctions when there's a difference between notarial and mortgage. But generally, they operate in very much the same way. So we have several different types of bonds. We have a general bond. What that means is that the bond is registered, let's say, over property for the sake of simplicity, for R1 million. You then have 20 years to pay off that bond, but let's say you decide to pay off 500,000 Rand tomorrow. A general bond will not allow you to then take that money out again. You have now paid up a certain portion of that bond, and it will remain that way. You cannot re-advance on that. A covering bond, this is the type of bond that we see more often than not, especially with in today's day and age. It means that it covers the lender for future debts as well. So that means that they can re-advance any funds that you've paid over and above. You might be familiar with this in terms of your Flexi facility or access bond. This is the type of bond that needs to be registered if you have that kind of facility. It makes it easier to save. A lot of people use these types of bond accounts to save extra money or, reduce your interest temporarily, but then you take it out later because you want to do a renovation. It gives you a lot of flexibility, but it has to be clear. The bond has to be drafted in such a way that it is clear that it is a covering bond. a surety bond. This is the type of bond that a third party would register in favor of a lender. We generally call them a mortgagee. That is the person in whose favor that bond is registered. So in this instance, let's say you have a company that needs to borrow some funds, but the company itself doesn't own any property. So the bank requires you as the director or the shareholder of that company to register a surety bond over your own property. So this is when a third party registers a bond in order to secure the debt of the primary lender, if that makes sense. This generally goes hand in hand with a surety agreement. So you are standing surety for in case your company does not repay its debts, in my example. Then we have an indemnity bond. An indemnity bond is a type of surety bond, but it almost operates like you would register an indemnity bond in favor of a surety. So let's use my example again, where you have a company which doesn't have property, or the bank doesn't find value in the property that the company has for whatever reason. Then you would have to stand surety. Perhaps you're putting up your home as a surety, so you're registering a surety bond over your home. And then you require from your company, because you're now standing surety for their debt, you require them to register an indemnity bond, perhaps over the equipment, so that you have a direct claim should the bank call upon you to pay any debts owed by your company. You can still secure what you are providing in terms of your surety with an indemnity bond. So it's a surety bond backed on a surety bond. It's but it operates very similarly. Then we have a collateral bond. This is also something we see more often in business type structures, is where a bond is registered over the company premises, let's call it that. And then the bank says, we're not quite sure whether the property is worth the 1 million rand that you say it is. So we require you to register a collateral bond over another property that the company owns. So the principal debt, the reason for the loan is perhaps for that property itself, but the bank wants extra security. So they will then require a collateral bond. And another one that we also don't see very often anymore, especially with the National Credit Act, and you have to be very careful when lending anyone money that you don't fall within the National Credit Act, is a kustingsbrief. And this is only related to mortgage bonds. You don't have this type of bond for notarial, but it is you wanting to buy a property for 1 million rand, but you only have 500,000 rand and you cannot get a loan from any other bank. So what we can then do is that we can transfer the property to you. We register a kustingsbrief over the property in favor of the seller, which is to secure the balance purchase price. So you obviously need a willing seller to be able to do this, but it just ensures that the seller retains a right in that property to ensure that you will be paying the balance of your purchase price. So that's where a kustingsbrief comes in. It used to be a lot more common practice, but not so much anymore. But it is still sometimes done. Now we talk about what can be bonded. So mortgage bonds, as I said, it's immovable property. So this can be over all immovable property. But the very important distinction here is that it is registrable in the deeds office, in a deeds office or the deeds office. So sectional title property, urban farms, anything like that, that can be registered in the deeds office. So you can't mortgage a portion of an earth. You can't mortgage half of a house. It has to be the registrable property as it is described in the deeds office. Then a notarial bond. This is any movable that you can identify. It has to be, the definition is really that it has to be easily identifiable without looking for external evidence of it. So when we draft notarial bonds, we look at serial numbers. If you're looking at machinery, you would look at the make, model, type, serial number, any identifying features that would set it apart from anything else that could be similar. So with a cell phone, you would also get a serial number. Diamonds, so jewelry is also often included. You would look in you would either do it by virtue of a photograph, or if it's actual diamonds, you can look at the GIA code on the diamond. That would be an identifying feature. But there's a very specific provision that aircraft and ships cannot be held under notarial bonds. They fall under different acts for the securing of any funding in relation to those. So when we talk about aircraft, we're talking hot air balloons, we're talking kites, even drones. All of those items cannot be bonded under a notarial bond. And ships, again, we're talking any kind of boats, any watercraft that cannot fall under this. Then the question is, who can register the bond? So only the legal owner of the property can register a bond. So this is why we have surety bonds. So in the example I used, where you have a company that you're wanting to help them secure, or help your company secure funds, that company cannot register a bond over your property, and that's why it's a surety bond, because only you can register it, but you can do it for someone else's debt. So you can stand surety, but only you can register it. If parties are married, in community of property, even if only the wife's name is on the title deed of the property, the husband has to consent, because he is, by virtue of the marriage and community, he is entitled to the property. So he has to also consent. Co-owners, everybody has to consent. And then companies, obviously the directors have to do that. And you'll hear mortgagee, or you've heard already about mortgagees and mortgagors. Just an interesting way, when I first did my conveyancing exam back in the day, it was difficult for me to remember which one's mortgagee, which one's mortgagor. And I had a very interesting lecturer or lady I went to for class, a very Afrikaans lady. She was lovely. And she said, the mortgagee gee die geld. So it's easy to remember that is the credit, or the credit provider, hy gee die geld. And the mortgagor is then the person who owes the money. I still sometimes, if I get a little bit confused, you think, okay, wie gee die geld? Interesting if you want to remember that. Then coming back to mortgage bonds, as I said, I'm going to be talking more about actual immovable property, and how many times, for those of you who've had owned homes with mortgage bonds on them, have you said the bank owns my house? But is this really true? When it comes to car financing, the bank actually does own your car. They have the registration certificate. That you have to pay that off before they'll give it back to you. It's registered in the bank's name. But when it comes to mortgage bonds, the bank does not own your property. They only have a registered real right. So the ownership remains with you, the owner. The bank cannot just come and take it away. They cannot just take the title deed and do anything with it. But with a mortgage bond, in that mortgage bond, there will be certain restrictions placed on your ownership. So you do own it outright and all of that, but there are restrictions placed by mortgagees. So these restrictions are often related to improvements. If you want to demolish half your house, you would have to get the bank's consent. We're talking about bank, but there could be other mortgagors as well, other financial houses. It could be, your parents, if you're lucky enough, because it affects the bank's security. So they need to consent to these types of things, because the house on the property itself is their security as well. So if you're going to demolish half the house, they're going to lose that. There will be conditions in there regarding insurance, that you have to maintain property insurance at all times. Again, they want to protect their security. If the house burns down, for instance, and it wasn't insured, there goes their security. Granting of servitudes, they'll have to consent to that, and there will most of the time in a well-drafted mortgage bond, there will be a clause that says you may not take out further bonds without the consent of the mortgagee, which means, and you'll see that this is generally why you can't have a bond from an ABSA and a Standard Bank. You have either one or the other. And if you have an ABSA bond and you take out a further bond down the line, it will be with the same mortgagee and you'll just register a second bond, but the bank will still have to consent to that. I'm just using those two banks as an example. Then what the relationship between mortgagor and mortgagee is determined, provides rights and obligations to both parties. So as a mortgagor, you have an obligation to repay your debt, failure of which you are in breach of your agreement, and the mortgagee may invoke their rights, as Stefan will discuss further. You have free use of the property subject to those certain limitations that I mentioned. There may be other limitations that are placed on a mortgagor by the bank, which will depend on the property, the type of property, what it's used for. And then obviously you have a right as the owner of the property, as the mortgagor, you have a right to sell your house and transfer your house, but that has to be done with the consent of the bank, which we will discuss. You cannot do it. You cannot actually move or transfer that property because there's that invisible bond that's sticking to the property that I tried to create a little visual earlier on. And then the mortgagee has a registered real right. So it's registered in the deeds office. It's enforceable against third parties. They will stand first in any to claim the funds from the sale of that property in the event of insolvency or anything. It is a registered real right, but remember that they do not actually own your property. So now you do want to sell your house, transfer it to someone else. How do you go about that? You have to get the consent to cancellation from the bank. We're talking bank, again, it could be another type of financial institution or private person. What they will then do is they will say there's an amount outstanding on the bond, but you're wanting to sell it. So they will come to an attorney and they will say, listen, I'm willing to consent to this the cancellation of this bond, provided that I receive 500,000 Rand for this bond that was initially 1 million. Then we would have to obtain a guarantee from the purchaser. Then the bank says, okay, happy with that, you can proceed to cancel simultaneously with the transfer, because if we do not deal with the bond, we can't transfer the property at all. But what happens if you've now paid up your bond and the outstanding balance is 0? So great, I'm moving on. And then you try and sell your house. And then the conveyancer says to you, but we see there's a bond registered over the property. Often what happens, clients say, oh, but it was paid up. Unfortunately, paying a bond up does not mean it's cancelled. You still cannot deal freely with that bond, with that property until the bond is cancelled. It's an act of registration, so there will still be some fees payable in that respect. I think at the moment it's about 5,500. So this is if you want to get your title deed back from the bank, or you want to do things to the property or with the property without anyone's consent. That is when that happens. I can't tell you in practice how many times I've had that come up where clients say, well, my bond's paid up, so there is no bond to cancel, but it's still registered against that title deed. The same with notarial bonds. It's a little bit more difficult because there's no title deed to machinery. There is no title deed to a ring. But what we do is, again, the legal owner of that property, we would go and search. Let's say in my personal capacity, I've got a Ferrari, which I've registered a notarial bond over. What we do is we go and do a deeds office search on a person's name and ID number, because it's in my personal capacity that I own the vehicle. And that notarial bond will be noted against my name at the deeds office. So there is a way to find out if goods have been secured. I can ask for a copy. Then it says, oh, it's a general notarial bond, which means all of my movable property has been bonded. or it's a very specific, just over my Ferrari, which means I can't sell my Ferrari without canceling that special notarial bond or getting the consent of the mortgagee to sell that property. Perhaps I need to replace the security with something else. But the next step in this is, what happens if we don't pay, and how does somebody actually realize their right to in respect of the property? So at this point, I'm going to hand over to Stefan, who is going to talk to us all about that.
Thank you very much, Janelle. Let me just quickly share from my side. Yeah, so thank you for that, Janelle. She's given us a quite comprehensive overview of the security that you can put in place by way of mortgage bonds and notarial bonds for. And as she said in the initial slide, in order to secure payment of monies or loans that you've advanced, or I'm not necessarily going to touch upon the commercial nature of it, as she set out with the covering mortgage bonds, surety mortgage bonds. As you'll see, I'm going to speak about it more in a general kind of perspective. Now, what does enforcement of bonds mean? And exactly as Janelle said, it means that you want to call up the bond in order to actually get paid what is owed to you. That is obviously done by way of a sheriff. It's not necessarily you going in there personally selling the house, or when it comes to the removals and the general notarial bond or special notarial bond, selling it yourself. It will ultimately be the sheriff that will be empowered to sell the property that's mortgaged or bonded by way of a general notarial bond in order to realize the debt owed to you. That's what it means to enforce a bond. So the first point that I want to make is that you need judicial oversight. As I've alluded to just now, is that you cannot take steps to sell those assets yourself as a credit. It will have to be done by way of a court order. The court has to look at the specific circumstance and the merits to determine whether you are entitled to enforce the bond. That will entail a few questions and investigations to put in. Firstly, you'll have to look at the underlying causa of the bonds. Again, here Janelle's explained all the various bonds, such as bonds registered because there was a loan advance or there's a suretyship in place, but those bonds will generally have an underlying document, like a loan agreement, suretyship, with specific terms setting out when the amount that is payable can be called up. So the first step, in order to see whether you can enforce your bond, which is obviously the end of the specific road that you're walking on, is to see whether, in terms of the document that you have in place, whether you're entitled to do that. Generally, let's focus on a loan agreement. It will have specific payment terms where installments have to be paid timelessly on specific dates. If the party is in breach, then you'll have to follow a breach period, and only then can you call up, for instance, only a specific portion of the loan amount or even the entire loan amount, depending on whether there's a form of an acceleration clause in there. But what I'm trying to illustrate, before you can actually come to the question of enforcing your bond, you have to see whether, in terms of your underlying documents, you're entitled to call up the amount being owed. And a point there that I see I didn't include in the slides is also to look at prevailing legislation and applicable legislation to see whether the specific amount can be called up. The most obvious piece of legislation that we're talking about here is the National Credit Act. It really sets out quite an extensive set of steps that a creditor has to follow in order to actually reach a stage where an amount can be called up. So when it comes to enforcing your bond, let's just look at the first step to see, in terms of your underlying documents, are you entitled to call up that amount? And that actually then just takes us into the next point. And again, as Janelle alluded to as well, you need to look at the terms of your bond itself. Not only do you look at the underlying documents, you need to see, in terms of the bond that it's registered, it sets out specific terms whether you can call up the bond based on what you agree to in that bond itself. And that can sometimes be further steps that you have to adhere to in addition to what your underlying document has set out. But it's important when it comes to that question of judicial oversight whether in terms of the underlying document and legislation, as well as the bond itself, you can call up the amount and then ask the court to enforce the bond. I'm not necessarily going to spend time as to what those terms can be. I've given you some examples. I think it's a bit more important that we deal with the nuances in the difference in enforcing your bonds, but it's important to know that your first step in order to enforce your bond is to get the court to consider the merits and the court to rule that you are entitled to call up your bond. We can talk, or I'm going to get to it shortly as to what that entails, how you approach the court. But I think just the first point that you'll always have to consider when it comes to enforcing your security is the court will have to make an assessment and rule on that. So I'm going to first talk about mortgage bonds, as Janelle said, registered over immovable property. Then I'm going to quickly jump over to notarial bonds. And there is obviously a difference, and there's a bit of a nuance in the approach of both securities and enforcing the bonds in terms of those securities. When it comes to mortgage bonds, as we said, it's registered over immovable property. And if you want to get a court to declare, what we call it, to declare the property specially executable, essentially the court will say, yes, you can now call up your bond. You are allowed to instruct the sheriff to go and sell the property in order to realize the debt owed to you in terms of your agreement. When it comes to a commercial property, it's a fairly vanilla approach, as I like to say. If in terms of the underlying document and the bond, you're entitled to call up that security, the court will generally rule and say you are entitled to sell the commercial property. But when it comes to residential property, that's when it starts getting a little bit more tricky, and the hoops that you as a creditor have to jump through are a lot more extensive as opposed to commercial property. So as I said, commercial property, if you comply with the terms of your underlying agreement and bond, you can get a court to rule that the property will be declared specially executable. Where it comes to residential property, and specifically where the residential property is the primary residence of the debtor, you're going to have to show to the court on an equity basis that you are entitled to now have that property declared specially executable. Because in our constitution, we've got right to housing, we've got a primary residence here. So the court, or at least the constitutional court, has developed the law to such an extent, in the sense that the court is not going to, in any circumstances, declare the property specially executable, i.e. not going to say that you can enforce the bond in any circumstances. Here we're looking at High Court Rule 46A, which specifically says that when it comes to primary residence, the court must make an assessment whether or not there are any alternative means to first satisfy the debt before the court says, yes, you can now sell the property. What alternative means are we talking about here? See whether the debtor possesses over sufficient movables to be sold in order to realize the debt. Emolument attachments, that refers to your, a good example here is that your salary or the debtor's salary is attached, where monthly payments are deducted directly from the employer to have payments made. And your Section 65 financial inquiries, what that refers to is Section 65 of the Magistrates Court Act, which entitles a creditor to do an investigation into the financial position of the debtor in order to hopefully get an order in place where, let's say, for 100,000 Rand debt, the debtor will be ordered to pay specific monthly installments. Those are just specific examples that I've listed for alternative means in which a judgment can be satisfied. So the court will, when it's faced with an application to have a property declared specially executable, first consider, when it comes to primary residence of the debtor, whether the creditor cannot satisfy it in any other way. Now, more often than not, I deal with mortgage bonds where it's home loans, where it's quite a significant amount outstanding, and generally we approach the court to say there's literally no other way in realizing this debt, and we want the property declared specially executable. But important to note, you have to set out quite an extensive motivation to the court why that debtor's primary residence should be declared specially executable. And should the court grant such an order that you can enforce that bond over the primary residence of the debtor, the court will also set a reserve price. Obviously, here we're looking at market value, municipal value. Ultimately, you have to motivate to the court what would be your reserve price, your base value, that the property must be sold on auction. Now, the question obviously will be posed, what happens if you cannot achieve that reserve price? If you reach such a scenario, then you'll have to go back to court, motivate to the court why the reserve price must be reduced. Ultimately, that specific provision was recently, or was included into our rules of court in order, of course, to preserve the underlying value of the asset. Here you're probably looking at examples historically where creditors sold properties where the debt was, I guess, in relation to the value of the property, perhaps only a few percent. And the court, of course, tried to avoid situations like that. But ultimately, the court also acknowledges the fact that you have specifically registered that mortgage bond over the movable property as security. So, of course, as I said again, a lot of hoops to jump through when it comes to primary residence. Although you have to jump through those hoops, I almost want to say that you will eventually reach a stage where you can enforce that bond. However, you have to really motivate the court to get to that point. So just in conclusion, when it comes to enforcing your mortgage bonds, there's a stark difference between how you approach it with commercial property and residential property. I think this should also be taken into account if in future you consider imposing condition of security to be put in place should you actually be a credit provider, and you can consider what specific bond you want to put in place, especially when it comes to the procedure that I've just explained in enforcing your mortgage bonds. But let's quickly jump over to that of notarial bonds. And here it gets a little bit more nuanced in the sense that, again, as Janelle explained, notarial bonds, general notarial bonds registered over specific property, although it's identifiable, it's not necessarily listed. So, for example that she used would be property at your factory that you trade, or that the debtor is trading from. It's not necessarily listed. Let's keep to the example that she used about the Ferrari. That's a specific asset that's listed that will fall under special notarial bond. It's specifically listed, whereas general is just a group of assets. So the difference in the approach of enforcing these bonds is quite important. When it comes to general notarial bond, before, and you'll remember from the previous slide, you need to get a court order that you can sell the assets. When it comes to a general notarial bond, it's quite important to note that you first have to perfect that bond. That's kind of the legal term that we have when it comes to enforcing bond. What that means and what that entails is you need to get the sheriff to judicially attach the assets and then take possession of those assets. So, again, talking about a leased premises, you've got a lot of machinery. Although in the general notarial bond, it's not necessarily itemized, but we're talking about the machinery at the premises. You, as the creditor, will then instruct the sheriff. You have to first get your court order authorizing the sheriff to go and attach those assets. That is perfecting your bond. What that then means is you've perfected the bond, you've attached the assets, then you can go to court to ask for an order that the debt in terms of the underlying document must be paid, and the assets that you've now attached by way of perfecting the bond can be sold. So it's quite important to note these extra steps when it comes to enforcing a notarial bond. Now, you're not looking at necessarily the equity consideration as we looked at when it comes to selling a primary residence, but again, you still have a few hurdles to jump through. When it comes to special notarial bond, you do not have to perfect, in the sense that you do not first have to get the sheriff to attach, and the reason why you don't have to do that is because in terms of your bond, that asset is already listed. All you need to do is go to court to get an order that you can proceed to sell that asset, which means the sheriff will then be entitled to sell it on auction. Just to add on what and Janelle also alluded to previously, that if you want to sell your assets that's bonded. Now, of course, when it comes to immovable property, that's as she said, it's quite simple. You cannot sell or transfer in the deeds office because there will be a mortgage bond registered. So as a creditor, you have that security. You don't really have to worry about the debtor disposing of the asset. However, when it comes to the notarial bonds, because the transfer of ownership of those assets are not necessarily dealt with in deeds office, there's obviously a little bit of a missing link when it comes to, how can I don't want to say oversight or regulating that, but just kind of keeping tabs on what the debtor is doing. So what I'm trying to get to in that instance is that you do get circumstances where debtors obviously sell off assets contrary to the terms of the notarial bond. And if you as a creditor catch wind of that, or there's a reasonable apprehension that may occur or is occurring, depending on your facts, you can also get a court order interdicting the disposal of those assets, because again, it's based on your notarial bond already registered over the assets and the underlying debt. To be honest, your debt doesn't necessarily have to be payable. At least you must prove the security. Again, you've got the security. You've got the first say to those assets in order to satisfy your debt, and you can then get an interdict. As a creditor, you can get an interdict against the debtor should they wish to sell those assets. There's another point I want to touch upon, and I think it kind of goes hand in hand with the example that you now used about the general notarial bonds registered over movables at a lease premises. So I think a question that would pop up would be, as a creditor, so as a creditor, where do you stand in relation to a landlord that has the hypothec over those properties? So as you would know, as a landlord, you've got in our common law a tacit hypothec over the movable property, which means it's almost exactly like a general notarial bond in the sense that the landlord will have the security over those assets, which the landlord can use to sell in satisfaction of rental outstanding. So question is, if you're a creditor with a general notarial bond over those assets, but you're not necessarily the landlord, where do you stand in relation to the landlord? Again, the landlord can also go and perfect the security of the hypothec and attach the assets and get a judgment for that outstanding rental to sell the assets. Now, when it comes to a general notarial bond, it is kind of a competition in the sense that the party who first perfects the security will be first in line. So essentially, basically just saying that if you're the creditor under the general notarial bond, you have to get in there first. If the landlord has attached the assets first, the landlord will enjoy that security. When it comes to a special notarial bond, again, you don't have to perfect, ergo the landlord security will rank second. I just thought that it's quite important that distinction also be just explained. And again, as I'm saying, is that as Janelle has explained all the various types of securities that you can consider in putting in place, I'm explaining how it's enforced, but that also actually ties in with your consideration what security you need to put in place. And all these steps that I've explained and how you enforce these bonds should also, in my view, be factored in when you consider insisting on security when it comes to advancing money, loan, or whatsoever the basis for the security be. And then just on the general side of enforcing your bonds, as we said, you need to get a court order, you need to get a judgment in place. Procedurally, just important to note, you can do it what we call either by way of application or action. An action is what we call you suing somebody, you've served a summons on them. What that means is that oral evidence will have to be given at trial. It's generally a lengthier process. But you also use that procedural route if there's a fear of a dispute of fact. So if either party is going to fight about what really the factual position is, like, is the money really due in terms of the agreement? Is there perhaps an argument of rectification of the agreement? That's when you will go down the line of an action. I think it's important to note, especially in our court, unfortunately, that can be a very long procedure. The court roll is extremely backed up lately. So yeah, that's the process when it comes to enforcing it by way of action. And then application is a proceeding that where your evidence is done by way of affidavits. The creditor will sign an affidavit in terms of which it wants the relief of the money being paid in the bond to be enforced. That is generally a quicker process. It only takes a few months to be resolved. But it's important to note in those circumstances, there isn't generally a factual dispute involved. And then just to note that each matter ultimately must be dealt with on its own merits. And that's why I also tied in with the terms of the underlying documents and the bonds. You need to specifically look at your facts, your merits of the matter, and your terms of your agreement and your bond, as well as prevailing legislation, whether you will actually be able to go down that route. We have just set up the basic principles in the law. It's quite important that each matter should be assessed on its own merits to determine whether you will be able to enforce your bonds. And then just when it comes to legal costs, generally the underlying documents will provide for legal costs to be paid by the debtor, and generally the mortgage bond also deals with that. Ultimately, your costs will still have to be taxed. It's done on a specific tariff. It has to be taxed by the taxing master, but ultimately you can then also recoup that against the security or selling of the movable property or the movables over which you had a notarial bond. So that's all from my side. It's actually supposed to be quite a straightforward process, but as I said, it can sometimes get a bit nuanced. So I think it's quite important that you ultimately speak to either Janelle or I, depending on where you're in the process, or maybe even speak to both of us when you're at the infant stages of actually advancing money or having to have certain security registered. I think it's quite important that you reach out to us. And I mean, we always have an ear to lend. So I think we're going to go over to some questions. I must just cancel my share.
Thank you so much, Stefan and Janelle. I think that was very insightful. So the only question that I see in the chat is for Stefan specifically, and that's from Maya. I hope I'm saying that correctly. Stefan, please touch on when it's necessary for a lender to register as a credit provider in terms of the National Credit Act.
Yeah, so historically, there was a specific threshold of what the value is of the amount that you're advancing, but currently it's at zero. So to be honest, everybody must register as a credit provider, and the repercussions of that, if you haven't registered and you have loan money and it is a credit agreement, fair enough. There are a lot of boxes to tick whether money is advanced in terms of a credit agreement. If you've advanced money and it is a credit agreement and you're not registered as a credit provider, then that agreement will be void, which means you will not necessarily enjoy the interest that's probably been catered for. But more importantly, there's unfortunately a prescription aspect to it, in the sense that from the date that you've advanced the money, which was advanced in terms of a void agreement, your cause of action would be different. It won't be the agreement. It will be an enrichment claim. And that enrichment claim will prescribe after 3 years. So that's probably a longer answer to a simple question. But it's important that if you advance money and it's in terms of a credit agreement as defined under the National Credit Act, it's important that you're registered, because there are quite serious repercussions.
And then maybe just to add to that, and I don't know if you know the answer, but what is the process to register as a National Credit Act provider? Is there just a website and you go through the link and prompts?
I'll be honest that I don't know the process. I don't necessarily deal with that. That's generally we refer clients to the National Credit Regulator, who obviously it's quite they will set out the time periods. I just want to just quickly, there was one question: loan to family members. That will generally be a loan that's not at arm's length, which would mean it probably won't fall under the National Credit Act. But please that's just a quick answer to it. By no means, I think I'll have to just look into that again. But yeah, it's not at arm's length, which means it's not a credit agreement in terms of credit act. So that's all from my side on that question.
Okay, and then I see from Jenny, what is the time frame to cancel a bond when you're wanting to sell or have sold your property, and how much notice does the bank need? So that one would be directed to Janelle. Janelle, you're still muted. Oh, wait, let me just. There we go.
Thank you. I was actually just typing a message that it wouldn't allow me to unmute myself. Okay, so Jenny, with regards to your question, there's no prescribed period that the bank requires notice. However, there is a 90-day rule that most of the banks have, which is, so you can cancel before 90 days is up, but then they charge a cancellation penalty, which is equal to the 90 days, the interest that you would have paid over 90 days. So it would depend where you are in your bond repayment schedule. But as time goes on, and let's say to registration of the cancellation, that penalty reduces accordingly. So we generally say, if you, let's say you sell your property today and you're wanting to register transfer within 3 months, then, you know, place that bond under cancellation as soon as possible in order to avoid any penalties. So you don't have to, you know, give them much notice. What it's going to depend on actually is getting those title deeds back from their securities, because they usually store them off-site. Yeah. And then I see there's another question that I'm just going to answer. Is there a way that married couple can buy a property without each other? So if you're married in community of property, unfortunately, by virtue of your marriage, you are both entitled to each other's property. But if you're married out of community of property, by all means, you can act on your own. You can take out a bond on your own. So, Lizanne, I hope that answers your question.
Then Stefan, I see there's one for you regarding the perfecting a bond and its process.
Yeah, so that, as I said, perfecting, that only relates to the notarial bonds, or actually the general notarial bond. What that entails is the creditor will have to get a court order in terms of which it's authorized to attach the assets. So again, the example that Janelle used was assets at a premises where the debtor is trading from. So what it means to perfect the bond is you get a court order authorizing the sheriff to go and attach those assets. That attachment, so you attach it under the guise of the general notarial bond. That attachment is how you perfect the bond, and then from there on you institute proceedings to get an order for the monetary judgment, and then ultimately getting an order that you're entitled to sell the assets. So the perfecting refers to that attachment. The sheriff must go and attach. So that perfecting means that you, how can I say, no, actually I don't have another word for it. You must just attach. I hope that answers, but you're more than welcome to phone me for any further questions.
Then I think, Stefan, and I'm hoping I'm not going to catch you off guard on this, but just in terms of the difference between the advancing of funds and with the National Credit Act and so on versus acknowledgement of debt, and the difference between those two type of agreements and how that would, you know, maybe just to clarify for the audience.
Well, I think your point of departure is always going to be whether the document actually, in terms of which you advance money, whether that comprises a credit agreement as defined in terms of the Act. Now, it gets, like I said, it gets quite tricky because a credit agreement, it refers to deferred payment where a fee is levied, where or interest is payable, and then you can also look at incidental credit. You can look at, unfortunately, there are various factors to accumulate, so it's not necessarily one answer. And to be honest, that's probably one webinar in itself. But it is quite important to note and to have that flag go off to that if you've got a document signed, even if it's just an AOD, whether that falls under the parameters of what a credit agreement is as defined in the Act.
Thank you. So I think we'll be making that another webinar. I see there's one last question or two last questions, one from Lizanne. Can a vacant land be used as surety?
Okay, so yes, of course. It is registered, it's registerable in the deeds office. So vacant land can be used, a mortgage bond can be registered over it. The only difference here would really be that the bank might not require any security because there's not security, I meant insurance, because there's nothing to be destroyed on the property. You can't destroy anything, and it has value. So yes, of course, you can use it as either surety or security under a bond. And then I see Jackie has also asked, what should a client do if they notify the bank of cancellation and then the buyer's bond doesn't get approved? So it's easy, you just revoke the cancellation. There is, however, a little warning that we like to give clients when they are placing their bond under cancellation, is that if you have an access facility, or recall I was talking about the covering bond, the flexi, the moment you notify your bank that you're placing your bond under cancellation, they will freeze your facility because they want to know exactly how much is outstanding so that they can request a guarantee, and they won't allow you to withdraw funds after that they've placed that under cancellation because of this reason. Then they might have a shortfall on their guarantee. But if your buyer's bond application doesn't get approved, you just notify the bank that unfortunately it's not proceeding. Can you please withdraw the cancellation? It doesn't cost you anything. It's just notice that you provide.
And then I think there's one last question from Luanda that will also be for Janelle.
Okay, what happens when you finish paying your bond and there's money you need to pay before you get the original? Yes, so if you've paid up your bond and you then place it under cancellation because you're not selling, you just want to get your title deed back, the bank will instruct their attorneys to attend to the cancellation. And the reason why you are paying a fee is because the bank has to send those deeds to an attorney. The attorney needs to draft certain documents, and that has to go to the deeds office for registration. So that is why there's a fee. It's a cancellation fee that's payable to the attorneys and to the deeds office. So that is, and then once that registration of that that cancellation has occurred, then your title deed will be endorsed to show that the title deed no longer has a bond over it, and then you can get the deeds back.
Thank you.
And
I
then
think then the last question we'll take is from Lizanne, but just before we finish up. So Stefan, that's one for you. Can an owner rent out a property if they can't afford the payment anymore?
Yeah, so the answer is yes. And Janelle can perhaps just nod here if I'm right or wrong, but some mortgage bonds sometimes it contains a term that rentals are automatically ceded to the mortgage. Or geez, see, now I don't know who here.
geld gee.
So firstly, you can rent it out. It's automatic. Sometimes terms that's automatically ceded, but I think just to tie in with the rider to that question, say that, but they have issued court auction, and that's quite important. Is that although you can rent it out, the court has now authorized the court auction. So unfortunately, that property can be sold on auction. Obviously, with the principle of huurgaasverkoop, that lease agreement will go over to the party that actually purchases it from out of execution. But I think to answer your question, yes, you can rent it out. Yeah, but Lizanne, you're welcome to phone me if that's not necessarily answers your question.
Perfect. So thank you so much, everyone, for the questions. And thank you, Stefan and Janelle, for your valuable insights and expertise on the matter. I think this was an exceptionally insightful webinar. So, and thank you, everyone, for joining us in today's session. Please be on the lookout for our next month's webinar. And you'll also be receiving the recording of the session afterwards, should you want to review some of the material. Again, thanks again, everyone, and have a great rest of the week.
Thanks all.
Thank you.